What's up, my hot diggity dogs? I haven't made a video today, or a long time even, but now I will. Most of my videos are cringe. This video will be cringe, but you know how in apps or in games, when you start it, it says agree to terms of service. Most people with a brain will skip that. But if you have the stupidity, like me, you'll actually read it. So I'm going to start reading the terms of service of Discord because it's short and sweet. Soon I'll be going into terms of service and policies that are longer. Eventually I'll meet up with the YouTube algorithm. Discord terms of service. Last modified May 7th, 2020. Important notice. These terms of service contain a binding arbitration provision and class action waiver. It affects your legal rights as detailed in the dispute resolution and class action waiver section below. Please read carefully. Introduction and accepting the terms. Welcome to Discord. These terms of service terms, which include and hereby incorporate the privacy policy at discord.com/privacy, meaning privacy policy, our legal agreement between Discord Inc. and its related companies, the company, us, our, or, we, and you, or your. By using or accessing the Discord application, the app, or the website located at https://discord.com or the site, which are collectively referred as the service. You agree that you are 13 years of age and the minimum age of digital consent in your country. If you are the age of majority in your jurisdiction or over, that you have read, understood, and accept to be bound by the terms, and I. If you are between 13 or the minimum age of digital consent as applicable. The age of majority in your jurisdiction that your legal guardian has reviewed and agrees to these terms. The company reserves the right to update these terms, which we may do for reasons that include, but are not limited to, complying with the changes to the law or reflecting enhancements to Discord. If the changes affect your usage of Discord or your legal rights, we'll notify you no less than 7 days before the changes take effect. Unless we state otherwise, your continued use of the service after we post modifications will constitute your acceptance of and agreement to those changes. If you object to those changes, your resource shall be to cease using the service. Rights to use the service. The service provides a chat and social platform. The service may allow you to participate in public and private chat rooms and to utilize messaging features to communicate with other users of the service. The service may also allow you to access certain software and/or other content that is available to purchase from the company. Subject to your compliance with these terms, the company grants you a limited, revocable, non-exclusive, non-transferable, non-sublicensable license to use and accept and access the service. You agree not to and to not attempt to use the service for any use or purpose other than expressly permitted by these terms. Copy, adapt, modify, prepared derivative works based upon distributive license, sell, transfer, publicly display, publicly perform, transmit, stream, broadcast, attempt to discover any source code, reverse engineer, decompile, disassemble, otherwise exploit the service or any portion of gathering and extraction tools on the service. No licenses or rights rights are granted to you by implication or otherwise any intellectual property rights owned or controlled by the company or its licenses, except for the permissions and rights expressly granted in these terms. The company reserves the right to modify or discontinue, temporarily or permanently, the service or any part thereof, with or without notice. The company reserves the right to refuse any user to the services without notice for any reason, including but not limited to the violation of the terms. If you violate these terms, the company reserves the right to issue a warning regarding the violation or immediately terminate or suspend any or all accounts you have created using the service. You agree that the company need not provide you notice before terminating or suspending your accounts, but it may do so. Your account. You're responsible for your login credentials and for any activity resulting from the use of your login credentials or other activity on your account on the service. Upon launching the app or service, if you do not already have an account, you will be prompted to create one, providing a username and in some cases a password. You may also be required to provide a valid email address or other information to access or utilize certain applications or features. You represent and warrant that the information you provide to us upon registration and that all other terms will be true, accurate, current, and complete. We reserve the right to reject any username or to terminate your username or prevent use of username in our sole discretion and without any liability to you. You understand and agree that other users of the service may have the same username as you. However, users will be differentiated by a number identifier to date at all times. We allow you to use the app without creating an account. Example, if we make available a single session use feature, any username you select for use in connection with the app will be available for other users after your session ends. You are responsible for maintaining the confidentiality of your login credentials and are fully responsible for all activities that occur the use of your credentials or otherwise on your account. You agree to notify us immediately if you believe the confidentiality of your login credentials have been compromised, or if you suspect unauthorized use of your account. You agree that we will not be liable for any loss or damage arising from unauthorized use of your credentials. Wow. Not even halfway. Communications. You agree to receive communications from us electronically, such as email, text, or mobile push notices, or notices and messages on the service. For any direct marketing messages, we will ensure that we obtain your consent first and also make it easy for you to opt out. We don't want you to send messages you don't want. By using the service or providing information to us, you agree that we may communicate with you electronically regarding security, privacy, and administrative issues relating to your use of the service. And all that agreements, notices, disclosures, and other communications that Discord provides to you electronically satisfy any legal requirements that such communications be in writing. You may use the service to send messages to others, users of the service. You agree that your use of the service will not include any unsolicited marketing messages or broadcasts. Example, spam. We may include a variety of means to block spammers and abusers from using the service. If you believe spam originated from the service, please email us immediately at support@discord.com. All rights, titles, and intellectual property rights. All rights, title, and interests in and to all materials that are part of the service, including but not limited to designs, text, graphics, pictures, video information, applications, software, music, sound, and other files, and their selection between arrangement. Except for your content, collectively referred as the service materials, are as between the company and you, owned by the company, and/or its third-party licensors. You may acknowledge and agree that you shall not require any ownership rights whatsoever by downloading service materials or by purchasing any virtual currency or virtual goods, each as defined below. You agree that you shall not modify, copy, distribute, frame, reproduce, republish, download, scrape, display, post, transmit, or sell in any form, by any means, in whole or in part, or otherwise exploit the service materials without our express prior written permission. You acknowledge that you do not acquire any ownership rights by using the service or by accessing service materials posted on the service by the company, or any derivative works thereof. All rights not expressed granted by these terms are reserved by the company and its licensors, and no license is granted hereunder by estoppel, implication, or otherwise. Your content. Any data, text, graphics, photographs, and their selection or an arrangement, and the other materials uploaded to the service by you is your content. You represent and warrant that your content is original to you, and then you exclusively own the rights to such content, including the right to grant all the rights and licenses of these terms without the company incurring any third-party obligations or liability arising out of the exercise of such rights and licenses. All of your content is your sole responsibility, and the company is not responsible for any material that you upload, post, or otherwise make available. By posting, distributing, transmitting, or otherwise using your content with the service, you grant to us a perpetual, non-exclusive, transferable, royalty-free, sub-licensable, and worldwide license to use, host, reproduce, modify, adapt, publish, translate, create derivative works from, distribute, perform, and display your content in connection with operating and providing the service. The company does not guarantee the accuracy, quality, or integrity of any user content posted. By using the service, you acknowledge and accept that you may be exposed to material you find offensive or objectionable. You agree that the company will not under any circumstances be liable for any user content, including, but not limited to, errors in any user content or any loss, damage incurred by use of user content. The company reserves the right to remove and permanently delete your content from the service or service with or without notice for any reason or no reason. You may notify the company of any user content that believes violates these terms or other inappropriate use or behavior by emailing abuse@discord.com. Rules of conduct and usage. The service provides us communication channels such as forums, communities, or chat areas. Communication channels designed to enable you to communicate with other service users. The company has no obligation to monitor these communication channels, but it may do so in connection with providing the service. The company may also terminate or suspend your account due to any communication channels at any time without notice for any reason. You acknowledge that any user content, including without limitation chats, postings, or materials posted by others on the communication channels, is neither endorsed nor controlled by us. The company will not, under any circumstances, be liable for any activity within communication channels. The company is not responsible for information that you choose to share on the communication channels or for the actions of other users. As a condition of your use of the service, and without limiting other obligations under these terms, you agree to comply with the restrictions and rules of use set forth in these terms or community guidelines, as well as any additional restrictions or rules, such as application-specific rules set forth in the service. As an example, you agree not to use the service in order to post, upload, transmit, or otherwise disseminate information that is objectionable, as outlined in our community guidelines. Defame, libel, ridicule, mock, stalk, threaten, harass, intimidate, or abuse anyone. Engage in conduct that is fraudulent or illegal, otherwise harmful to Discord and any other user. Upload or transmit, or attempt to upload or transmit files that contain viruses, Trojan horses, worms, time bombs, cancel bots, corrupted files or data, or any similar software or programs, or engage in any other activity that may damage the operation of the service or users' computers. Violate the contractual, personal, intellectual property of other rights of any party, including using, uploading, transmitting, distributing, or otherwise making available any information made available through the service in any manner that infringes any copyright, trademark, patent, trade secret, or other right of any party, including rights of privacy and publicity. Attempt to obtain passwords or other private information from other members. Properly use support channels or complaint buttons to make false reports to us. Develop, distribute, or publicly inform other members of auto software programs, macro software programs, or other cheat utility software program or applications in violation of the applicable license agreements, or exploit, distribute, or publicly inform other members of any game error, miscue, or bug which makes an unintended advantage, violate any applicable laws or regulations, or promote or encourage illegal activity, including but not limited to hacking, cracking, or distribution of counterfeit software, compromised accounts, or cheats or hacks for the service. These rules of use are not meant to be exhaustive, and we reserve the right to determine what conduct we consider to be a violation of the terms, community guidelines, or improper use of the service, to taking action including termination of your account and exclusion from further participation in the service. Feedback. We appreciate hearing from our users and welcome your comments regarding the service. If you choose to provide feedback, comments, or suggestions for improvements to the service or otherwise in written or oral form, feedback, you represent and warrant that A. You have the right to disclose the feedback. B. The feedback does not violate the rights of any other person or entity. And C. Your feedback does not contain any confidential or proprietary information of any third parties or parties. By sending us any feedback, I agree that we are under no obligation and confidentially express or implied with respect to the feedback. 2. Acknowledge that we may have something similar to the feedback already under consideration or in development. 3. Grant us irrevocable, non-exclusive, royalty-free, perpetual worldwide license to use, modify, prepare derivative works from, publish, distribute, and sublicense the feedback. And 4. Irrevocably waive and cause to be waived against Discord and its users in any claims or assertions of any moral rights contained in such feedback. This feedback section shall survive in any termination of your account or the services. All rights in this section are granted without the need of additional compensation of any sort to you. Third-party content. We use third-party services to help us provide the service, but such use does not indicate that we endorse them or are responsible to liable for their actions. In addition, the service may link to third-party websites to facilitate its provision of services to you. If you use these links, you will leave the service. Please note that your use of such third-party services will be governed by the terms and privacy policy applicable to the corresponding third party. Some of the third-party websites may use service materials under licensing from us. We are not responsible for, nor do we endorse these third-party websites or the organizations sponsoring such third-party websites or their products or services. Whether or not we are affiliated with such third-party websites, you agree that we are not responsible for or liable for any loss or damage to any sort of incurred as a result of any such dealings you may have on or through a third-party website, or as a result of the presence of any third-party advertising on the service. User disputes. You are solely responsible for your interaction with the other users of the service and other parties that you come in contact through the service. The company hereby disclaims any and all liability to you or in any third party relating to your use of terms of service. The company reserves the right but has no obligation to manage disputes between you and users of the service. Copyright complaints. The company respects the intellectual property of others, and we ask our users to do the same. If you believe that your work has been copied in a way that constitutes copyright infringement, or that your intellectual property rights have been otherwise violated, you should notify the company of your infringement claim in accordance with the procedures set forth below. The company will process and investigate notices of alleged infringement and will take appropriate actions under the Digital Millennium Copyright Act, DMCA, and other applicable intellectual property laws with respect to any alleged or actual infringement. A notification of claimed copyright infringement should be emailed to the company's copyright agent at copyright@discord.com. Subject line: DMCA takedown request. You also may contact us by mail at Discord. Attention, DMCA takedown request. 444 DeHaro Street, number 200, San Francisco, California, 94107. To be effective, the notification must be in writing and contain the following information: an electronic or physical signature of the person authorized to act on behalf of the owner of the copyright or other intellectual property interest, a description of the copyright work or other intellectual property that you claim has been infringed, a description where the material that you claim is infringing is located on the terms of service with enough detail that we may find it on the service, your address, telephone number, and email address. The statement by you have a good faith belief that the disputed use is not authorized by the copyright or intellectual property owner, its agent, or the law. A statement by you made under penalty of perjury that the above information in your notice is accurate and that your copyright or intellectual property owner or authorized to act on the copyright or the intellectual property owner's behalf. If you submit a notice of infringement that knowingly, materially misrepresents that any content, information, or community on a service is infringing upon a copyright, you may be held liable for the damages and attorney's fees. Counter notice. If you believe that your content was removed or which access was disabled is not infringing, or that you have the authorization from the copyright owner, the copyright owner's agent, or the pursuant to the law to upload and use the content in your content, you may send a written counter notice containing the following information to the copyright agent. Your physical or electronic signature, identification of the content that has been removed or to which access has been disabled, or the location at which the content appeared before it was removed or disabled. A statement that you have good faith or belief that the content was removed or disabled as a result of a mistake or misidentification of the content, and your name, address, telephone number, and email address, a statement that you consent to the jurisdiction of the federal court located within the Northern District of California, and a statement that you'll accept service of process from the person who provided notification of the alleged infringement. If a counter notice is received by the copyright agent, the company will send a copy of the counter notice to original complaining party, informing that person may replace the removed content or cease disabling it in 10 business days, unless the copyright owner files an action seeking court order against the content provider, member, or user. The removed content may be replaced or access to it restored in 10 to 14 business days or more after receipt of the counter notice at their sole discretion. Repeat infringer policy. In accordance with the DUMCA and applicable law, the company has adopted a policy of terminating inappropriate circumstances at the company's sole discretion users who are deemed to repeat infringers. The company may also, at its sole discretion, limit access to the service and/or terminate the memberships of any users who infringe any intellectual property rights of others, whether or not there is any repeat infringement. Termination. You may terminate your account at any time, and for any reason, by deleting your account through the user settings page in the application. The company may terminate your account and your access to the service, or at the company's sole option, applicable portions of the service at any time for any reason. The company is not required to provide you with any notice warning prior to such termination. You may, as the result of termination, lose your account and all information and data associated therewith, including without limitation your virtual currency and virtual goods as applicable, and the company is under no obligation to compensate for you for any such loss. We're almost halfway there. Disclaimer of warranty. The services and the service materials are provided as is and as available without warranties of any kind, either express or implied, including, but not limited to, implied warranties of merchantability, fitness, or particular purpose, title, and non-infringement. Your use of the services at your sole risk. In addition, while the company attempts to provide a good user experience, we cannot and do not represent or warrant that the services will always be secure or error-free, that the services will always function without delays, disruptions, or imperfections. The foregoing disclaimers shall apply to the extent permitted by applicable law. Limitation of liability. To the maximum extent permitted by law, in no event will the company be liable to you or to any third person for any consequential incidental, special, punitive, or any indirect damages, including any lost profits or lost data arising from your use of the service or other materials on, accessed through, or downloaded from the service, whether based on warranty, contract, tort, or any legal theory, and whether or not the company has been advised of the possibility of these damages. The company shall not be liable for more than the greater of the amount you have paid to us in accordance with these terms in the 3 months immediately preceding the date which you first assert a liability or alter rights that cannot exclude under applicable law. Some jurisdictions do not allow the exclusion or implied warranties or limitation of liability for incidental or consequential damages, which means that some of the above disclaimers and limitations may not apply to you. In these jurisdictions, this court's liability will be limited to the greatest extent permitted by law. You specifically acknowledge that the company shall not be liable for user content, including without limitation, your content or the defamatory, offensive, or illegal conduct of any third party, and that the risk of harm or damage from the foregoing rests entirely with you. Thus word. You agree to indemnify and hold the company harmless from and against any loss, liability, claim, demand, damages, costs, and expenses, including reasonable attorney's fees arising out of or in connection with your use and access to the service. 2, your violation of any term of these terms. 3, your violation of any third-party right, including without limitation and copyright, property, or privacy right or any third-party agreement. Or 4, any of your content or information in your account or any other information you post or share on through the third service. As used in this section, you shall include anyone accessing the service using your password. Virtual currencies, virtual goods, and terms of sale. We will not charge you a fee to the basic functionality of the service, but fees may be charged for certain products and services. For additional terms regarding our Nitro subscription service, please see the Nitro subscriptions section below. The service may include an opportunity to obtain virtual currency, or virtual goods that may require you to pay a fee using legal tender, that is, real money, to obtain the virtual currency or virtual goods. Your purchase of virtual currency is final and is not refundable, exchangeable, transferable, except in the company's or the platform provider's sole discretion. You may not purchase, sell, or exchange virtual currency outside the service. Doing so is a violation of the terms and may result in a termination of your account with the service or legal action. The company retains the right to modify, manage, control, or eliminate virtual currency or virtual goods at its sole discretion. Prices and availability of virtual goods are subject to change without personal, non-transferable, non-sublicensable permission to use solely within the service virtual goods and virtual currency they have earned, purchased, or otherwise obtained in a manner authorized by the company. You have no other right, title, interest in or to any such virtual goods or virtual currency appearing or originating in the service. Product descriptions. We try to make the service thorough, accurate, and helpful to our customers. Nonetheless, there may be times where certain information contained in the service may be incorrect, incomplete, inaccurate, or appear inaccurate because of the browser, hardware, software, or other technology that you use. Discord reserves the right, with or without prior notice, to change descriptions or references to products and/or services, limit the available quantity of products or service, honor the refuse to honor any coupon code, promotional code, or any similar promotions, and/or to provide any visitor or any use of the service with any product or service. Availability and pricing. Though we try to honor all purchasable requests, availability cannot always be guaranteed. When an item is not available and cannot be replenished, for example, if we offer a limited promotion, we will attempt to remove the item from the service in a timely manner, but make no guarantees in this regard. We may occasionally make errors in the stated prices of the service. If a product's correct price is higher than the listed price, we will either confirm that we'll provide the item at the price listed or cancel your order and notify you of such cancellation. Payments. We accept major credit cards, certain debit cards, PayPal, and Slash, or such other payment methods we make available to you from time to time through our service as forms of payment method. We may also offer the ability to make orders through a third-party app store or other payment service. You may agree to comply with the terms and other requirements they may have. By submitting an order, you authorize Discord or its designated payment processor to charge the account you specify for the purchase amount. We may, in our sole discretion, cancel your payment at any time, providing notice to you through your contact information by a notice when you attempt to make a payment. We cancel a payment or prevent you from initiating future payments for any reason, including without limitation the following. 1. If you attempt to use the service in breach of any applicable law or regulation, including the card network's rules and regulations. 2. If you use the service in breach of these terms. 3. If we suspect fraudulent, unlawful, or improper activity regarding a payment. 4. If we detect our sole discretion that your payments have excessive disputes, high reversal rates, or present a relatively high risk of losses. Or 5. Failure to cooperate in an investigation or provide additional information when requested. Refunds. You can find a refund policy here. No. Taxes. Stated prices may not include sales and use taxes. If they do not, you are responsible for the payments of such taxes related to your purchase. We have the right to charge for you of any taxes that we are required to pay, in fact, collect related to your purchase. International orders. You will be solely responsible for any license fees, customs duties, and other taxes and fees related to the export of products from the United States. Manufacturers, EULAs, and other terms. You may be required to accept the user agreement, EULA, or other terms provided by the manufacturer prior to the use of product that you order. A EULA, as other terms, may accompany the product you order. Nitro subscriptions. Recurring billing. By purchasing a Nitro subscription, you authorize us to charge your payment method on a recurring, example monthly or yearly basis for the applicable Nitro subscription charge. Any and all taxes or possible transaction fees and any other charges incurred in connection with your use of the Nitro subscription service. Your payment to Discord will automatically renew at the end of your applicable subscription period unless you cancel your subscription before the end of the current subscription period. Price charges. Discord may change the price for Nitro subscriptions from time to time and communicate any price changes to you in advance, and if applicable, how to accept those changes. Price charges for Nitro subscriptions will take effect at the start of the next subscription period following the date of the price charge. As permitted by local law, you accept the new price by continuing to use Nitro after the price change takes effect. If you do not agree with the price changes, you have the right to reject the change by unsubscribing from Nitro prior to the price change going into effect. We don't want to charge you for something that you don't want, though if you cancel within 14 days of price increases, we'll provide you a refund. Cancellation. You may cancel your Nitro subscription at any time and may continue to have access to Nitro through the end of the current subscription period. If you cancel your subscription before the end of the subscription period, you will not refund any subscription fees already paid to us. At our sole discretion, however, we may provide refund, a discount, or any consideration to some of our members. Credits. The provision of credits in one instance does not entitle you to credits in the future of similar distances, nor does it oblige us to provide credits in the future under any circumstance. To cancel, go to the user settings screen in the Discord desktop or mobile app and follow the instructions for cancellation. Dispute resolution. This section and the next section only applies if you are a United States resident. I don't care, I'm Canadian, I'll do this American shit. Please read this section carefully. It may significantly affect your legal rights, including your right to file a lawsuit in court. You and Discord agree to these terms of service affect interstate and commerce, that the Federal Arbitration Act governs the interpretation and enforcement of these arbitration provisions. You and Discord agree that the terms affect interstate commerce and the Federal Arbitration Act governs the interpretation and enforcement of these arbitration provisions. Most disputes can be resolved without resorting to arbitration. In the event of dispute, you agree to provide us notice of the dispute. This notice provide a brief written description of the dispute, the relief requested, and the contact information by the party giving it. You must send any such notice to Discord email by disputes@discord.com and by U.S. mail to Discord Inc. 444 D. Harrow Street, number 200, San Francisco, California, 94107. The parties agree to use their best efforts to settle any dispute, claim, question, or disarrangement directly through consultation with one another, and good faith negotiations shall be in a condition to either party initiating a lawsuit or arbitration. Notwithstanding the foregoing disputes or concerning patents, copyrights, immortal rights, trademarks, and trade secrets, and claims of piracy and unauthorized of the site shall not be subject to arbitration, and the notice and good faith negotiation required by this paragraph shall not apply to these types of disputes. Binding arbitration. Except as provided herein, if we cannot resolve the dispute informally, any dispute will be resolved and only by binding arbitration to the held U.S. state of which you reside. For residents outside the United States, arbitration shall be initiated in San Francisco, California. Discord and you further agree to submit the personal jurisdiction of any federal court in San Francisco, California to compel arbitration stay proceedings pending arbitration, or to confirm, modify, vacate, or enter judgment on the award entered by the arbitrator. The arbitration shall be conducted by a single arbitrator, governed by the rules of JAMS that are in effect at the time of the arbitration is initiated. This word. Referred as to the JAMS rules, and under rules set forth in these terms. If there is a conflict between the JAMS rules and the rules set forth in these terms, the rules set forth in these terms will govern. Arbitration means that you waive your right to a jury trial. They may, in arbitration, seek all remedies otherwise available to you pursuant to your state's law. To the extent filing fee or the arbitration exceeds cost of filing a lawsuit, this court will pay the additional cost. This court shall also bear the cost of arbitration fees unless the arbitrator finds your claims, defenses, and other fee-generating activity to be asserted or conducted for any improper purpose or frivolous. If you are responsible for any additional costs that may incur in the arbitration, including without limitation attorney's fees or expert witness costs, unless this court is specifically required to pay such fees under applicable law. The decision of the arbitrator will be in writing and binding and conclusive on this court, and judgment to enforce the decision may be entered in any court of competent jurisdiction. This court and you agree that dispositive motions, including without limitation motions to dismiss and motions for summary judgment, will be allowed in the arbitration. The arbitrator must follow these terms of service, can award the same damages and relief as a court, including injunctive or other equitable relief and attorney's fees. This court and you understand that absent this mandatory arbitration provision, this court and you would have the right to sue in court and have a jury trial. This court and you further understand that in some instances the cost of arbitration could exceed the cost of litigation and that the right to discovery may be more limited in arbitration than in court. Almost done. That took so long. It's taking so long. If this court or your claim is solely for monetary relief of $10,000 or less and does not include a request for any type of equitable remedy, the party bringing the claim may choose whether the arbitration of the claim will be conducted through a telephonic hearing or by an in-person hearing under the JAMS rules, solely based on documents submitted to the arbitrator. You and this court may choose to pursue claim in small claims court where jurisdiction and venue over you and this court otherwise qualifies for such small claims court, and where court does not include requests for any type of equitable relief. However, you decide to pursue a claim in small claims court. Yes, you agree to still provide Discord with advance notice by email to disputes@discord.com and by U.S. mail to Discord 444 D Harrow Street, number 200, San Francisco, CANINEFOUR ONEZEROSEVEN. Opt-out right. You have the right to opt out and not be bound by the provisions arbitrating by sending a written notice of your decision to opt out to this court's email by arbitration-opt-out@discord.com. The notice must be sent within 90 days of terms of service taking effect or your account creation of the service. If you do not opt out via this method, you will be bound to arbitrate disputes in accordance with the services of the paragraphs. If you opt out of the provisions requiring arbitration, Discord will not be bound by them either. If any clause with this arbitration section is found to be illegal or unenforceable, that specific clause will be served from the section, and the remainder of this provisions will be given full force and effect. Survival. This arbitration section shall survive any termination of your account or the service. This section and previous section only applies if you are a United States resident. I don't care. Please read the section carefully. It may significantly affect your legal rights. Okay. Discord and you agree to resolve any dispute in individual capacity and not behalf of or as part of any purported class, consolidated, or representative proceeding. Sorry. The arbitrator cannot combine more than one person or entity's claims into a single case and cannot preside over any consolidated class or represented proceedings unless we agree otherwise. And the arbitrator decision award in one person's or entity's case can only impact the person or entity that brought the claim, not other Discord members, and cannot be used to decide other disputes with our customers. Any court or arbitrator determines that the case consolidated representative action waiver set in force in this section is void or unenforceable for any reason, or that arbitration can proceed on a class, consolidated, or representative basis, then disputes, claims, or controversies will not subject to arbitration and must be litigated in federal court located in San Francisco, California. This class action waiver section shall survive in any termination of your account or the services. International use. Export controls. Software available in connection with the service and the transmissions of applicable data, if any, is subject to the United States export controls. No software may be downloaded from the service or otherwise exported or re-exported in violation of U.S. export laws. Downloading or using the software is in your sole risk. Recognizing the global nature of the Internet, you agree to comply with all the rules and laws regulating your use of the service as it concerns online conduct and accept content. iOS applications. I don't have iOS, but I'll read it. The following additional terms and conditions apply with respect to any app the company provides you, designed for use on an Apple iOS-powered mobile device, an iOS app. You acknowledge that these terms are between you and Discord only and not with Apple Inc. Apple. The use of company's iOS app must comply with Apple's then current App Store terms of service. The company and not Apple are solely responsible for iOS app and the services and content may be thereon. You acknowledge that Apple has no obligation to provide maintenance and support services with respect to our iOS app. To the extent permitted by applicable law, Apple will have no warranty obligation whatsoever with respect to our iOS app. You agree that the company and Apple are responsible for addressing any complaints by you or any third party relating to our iOS app or your possession and or use of our iOS app. You agree that the company and not Apple shall be responsible to the extent required by these terms for the investigation, defense, settlement, and discharge of any third-party intellectual property infringement claim related to our iOS app and your possession use of iOS app. If you want to represent one, you are not located in a country that is subject to a U.S. government embargo or has designated the U.S. government as a terrorist-supporting country, and two, you are not listed any U.S. government list of prohibited or restricted parties. You agree to comply with all applicable third-party agreements when using our iOS app. Example, you must not be in violation with our wireless data terms of service of agreement when using the iOS app. The parties agree that Apple and Apple's subsidiaries are third-party beneficiaries to the terms that they relate to your license of the company's iOS app. Upon this acceptance of these terms, Apple will have the right and will be deemed to have accepted the right to enforce the terms against you as they relate to your license of the iOS app as third-party beneficiary thereof. General governing law. By visiting or using the service, you agree that the laws of the United States and the state of California, without regard to the principal conflict of laws and regardless of your location, will govern these terms of service. Any dispute of any sort that might arise between you and the company, any claim dispute where you and the company arises out of or is related to the service is not subjective to arbitration and shall be decided exclusively by court of competent jurisdiction located in San Francisco, California. And you hereby consent to and waive all defenses of lack personal jurisdiction and forum non-convenience with respect to venue and jurisdiction in the state and federal courts in San Francisco County, California. Injunctive and other equitable relief. You acknowledge that the rights granted obligations made to the company under these terms are of unique and irreplaceable nature, the loss of which may result in immediate and irreparable harm to the company, which remedies at law are inadequate. The company shall therefore be entitled to seek injunctive or equitable relief without the obligation to post any bond or surety or surely. Okay, surely. In the event of any breach or anticipatory breach by you, you irrevocably waive all rights to seek injunctive or any equitable relief. Entire agreement. The terms of service constitute the entire agreement between you and the company with respect to your use of the service and any other subject matter of hereof cannot be changed or modified by you as expressively posted on the service by the company. You also may be subjected to additional terms of service conditions that may apply when you use affiliate or third-party services, third-party content, or third-party software. Waiver. The failure of the company to exercise or enforce any right or provision of these terms shall not constitute waiver of such right or provision, and no waiver by either party of any breach or default hereunder shall not be deemed to be a waiver of any preceding subsequent breach or default. Severability. If any of provision of these terms found by court of competent jurisdiction to be invalid, the parties nevertheless agree that the court should endeavor to give effect to the parties' intentions as reflected in the provision, and the other provisions of these terms shall remain full force and effect. Neither the course of conduct between the parties nor trade practice will act to modify these terms. Agreement. These terms may not be assigned by you or without the company's prior written consent, but are freely assignable to the company by the company. Subject to the foregoing restriction, these terms will be binding on inure to enforceably against the parties and their respective successors and assigns. Documentation of compliance. Upon the company's request, you will furnish the company with any documentation, substantiation, or releases necessarily to verify with your compliance with these terms. Interpretation. You agree that these terms will not be construed against the company by virtue of having drafted them. defenses based on electronic forms of these terms. You hereby waive any and all defenses you may have based on the electronic form of these terms and the lacking of sign by these parties here to exclude these terms. If you agree that the provisions of the terms that by their nature should survive termination will survive termination of these terms, contact. If you have any questions about these terms, please contact privacy@discord.com. Discord is made possible through the work of other open source software. Woo! I have finished the terms of service of Discord, and it is now a relief. Now my vocal cords can rest. Goodbye.